Right. So tonight we would like to discuss sociological jurisprudence. So sociological jurisprudence, as the term itself suggests, sociology, that is the study of society. Yeah. So sociological jurisprudence is an attempt to understand law through social context. So how can we understand the phenomenon of law by looking at it from the point of view of how society functions, how society interacts? So that is basically what we are seeking to do. So sociological jurisprudence examines how law interacts with social norms, and also it's influenced by social norms, behaviors, and practices. So there is what you call forward and backward linkage or relationship. Or there's some kind of a symbiosis between law on one hand and then various societal norms, various behaviors and practices. So therefore, is it the case that are the social norms which actually give rise to law, or law influences social norms, behaviors, and practices? And of course, it is a very much reflection of the dynamism which is at play. The fact that law is not static. Law is evolving. Evolving means that it is going through transformation, it's going through changes. And of course, from the point of view of sociological studies, law will be seen as one of institutions of society, one of social institutions, to use the language of a sociologist. And if society is seen as dynamic, society is seen as being in a state of flux, going through changes every now and again, then it follows that law, which is one of the various institutions of society out there, would also not stand still. It will also evolve and go through changes. So the key premise, or the fundamental point, which sociological jurisprudence is making, is that law transcends mere rules and regulations. Law goes beyond mere rules and regulation. In other words, law is not just equal to rules and regulation and you are finished. No. Law is an integral part of the societal fabric, the DNA of society, how society is organized and structured. Law is very much important part of it. And for that matter, law influences, and law is influenced by social forces. And that is why I said that it's that kind of symbiotic relationship, that kind of symbiosis. I influence you, you also influence me, as it were. So law serves not only to govern, but law also serves to reflect and shape societal values and interactions. And the point about sociological jurisprudence as an approach to inquiry or studies into the nature of law is that it helps in understanding the practical impacts of laws and guides more effective legal reforms aligned with social changes. And that is why we can call it the law in action, the law in social context. So that is sociological jurisprudence. So therefore, if we're talking about law, we don't know the rare nature, the rare ramifications of law yet until we observe its interaction with society, until law is actually deployed, is set in motion, and then we see how it influences society. That way, we get a better insight into law. Or we cannot understand law the way that it is configured, the way that it is framed, unless and until we observe society, understand the various interactions which have gone on in society, and see how those interactions affected what we are seeing as the law. So there's no doubt that sociological viewpoint or perspectives are important in doing legal analysis, because if you use sociological perspective or approach, it will help us to have laws that are not only just, but also pragmatic and socially relevant. If we ignore the sociological viewpoint, you will make a law which is not fit for purpose, a law which does not serve society well. So that is the point we should keep in mind. So, and I give you a typical example. It's just like those who are development experts, that if you want to do development in a new project in a community, it is very important to engage the community and really understand what is important to the community, rather than you just doing anything for them. So a story is, for example, told of a certain rural community where someone went to do modern type of toilet, right? The water closet or WC. Now, that community, they had their own type of toilet, which many years they are used to. So when this water closet types were actually installed, they didn't know about it. So they thought that it was meant to be used for some other purposes instead of the usual purpose that we put it to. So here, you've done something which does not align with what the expectations of the people are. So the same thing can apply to law. If you ignore the social context, you run into problems. And that is why sociological perspective is important, because when it is incorporated into legal analysis, it promotes laws that are not only just, but also pragmatic and socially relevant. The third thing is to come out with laws where, after making the laws, there will be huge disconnect between what is done on the ground and then what the law envisages to be done. And it happens all the time. So who are the main thinkers who started the pioneer work of this kind of analysis that we now have sociological jurisprudence? Well, we will talk of Rudolf von Jhering. Rudolf von Jhering, he, among other things, saw law as a means to social ends and not just a collection of rules. So, end is the objective or the purpose, the target. Remember teleosociology and teleological when we're discussing natural law. So that is end and the means So he's saying that law is not an end in itself. Law is a means to social end. And of course, this also resonates with you, because not too long ago you discussed Marxist jurisprudence. And Marxist jurisprudence, we're told that law is seen one of the instruments for class oppression. So in that perspective, law over there is also seen as a means, not as an end in itself. And so sociological jurists like Rudolf von Jhering is also making the point that law is a means to social end, not just collection of rules. So he has, Jhering has what we call the instrumentalist view, by which he means that law is seen as a tool for achieving societal goals, a tool or means for achieving societal goals. So that is to say that we should know what the goals of society are. What goals are we trying to achieve? So once we are clear about the goals, then we try to craft, we try to calibrate, we try to formulate the law in such a way that it will help us to attain those goals. So that is the point Jhering's instrumentalist view of law is telling us. And so that promotes the idea that law should work to balance interests and social functions. With the various interests in society, various functions society as a collective is supposed to serve. Now, the interests which are in society may not be in harmony all the time. Some may contradict or may produce tension. So therefore, law should be deployed in such a way that it's able to mediate these tensions between various interests and social functions, as it were. So there is this famous quote, of course, attributed to Rudolf von Jhering, that the end of law is peace. The means to this end is a fight. Peace through struggle is the law's motto. I take it again. Jhering is said to have said that the end of law is peace. The means to this end is a fight. Peace through struggle is the law's motto. We have another pioneer of sociological understanding of law, that is Eugene Ehrlich. Eugene Ehrlich focused on what we call living law. Living law. And by that, he meant law as found in everyday life and social interactions beyond formal statutes. So Eugene Ehrlich is saying that law is not so much about that which you see in the statute books, right? What you see in the laws of Ghana, the House of Parliament, the Constitution, and so on. But more importantly, what you find in everyday life and social interactions, what he calls the living law. So his concept of living law asserts that the most effective legal norms are those observed by a community in their daily interactions, which is often independent of written law. So that is what he means by the living law. So every day, as we relate to one another, the things that we do, the things that we refrain from doing, we see certain principles which are behind the way that we relate to one another, we deal with one another. And according to Eugene Ehrlich, that is the real law, that is the living law, and not necessarily what you see in the statute or in the tablet of the law, so to speak. So he also had this famous quotation that is Eugene Ehrlich, that quote, "The center of gravity of legal development is not in legislation, nor in juristic science, nor in judicial decision, but in society itself." I take it again. According to Eugene Ehrlich, the center of gravity of legal development is not in legislation, nor in juristic science, nor in judicial decisions, but in society itself. So that is the focus, that is the heartbeat of legal development. If you want to understand law, he's saying that don't just look at legislation or acts of parliament and be satisfied that you have really seen the law. Or don't worry yourself so much about the various case laws and commentaries on them and various academic analysis. But more importantly, study society. Look at society. That will help you to understand how the law develops. So that is the point that he's trying to make. Zach, I'm teaching online. You can go home. Okay, all right, thank you. So that is the point he's trying to make. So let's say a bit few more things about the impact or contribution of Rudolf von Jhering to sociological development or sociological jurisprudence. And we see his contribution in one phrase, that he saw law as a social instrument. Law as a social instrument, or law as a social tool. And as we have noted, Jhering, he saw law not just as a system of rules, but as a dynamic instrument for social balance and progress. A tool which you leverage on, which you make use of in order to achieve social balance and also ensure social progress. So that is his conceptualization of law as a social tool. So Jhering made the argument that the main purpose of law is to actively shape society. To actively shape society and also ensure that law serves as a mediator to balance competing interests and foster social harmony. I mean, whether you like it or not, we live in society made up of different people with different interests, different orientation, different perspectives, right? Even if you are to come to a family, let's take even a simple family, a family of, let's say, 5, a mother and father, let's say 3 children, or whatever. In a small group like that, each member has got his or her own interests, his or her own idiosyncrasies, perspectives, and so on. And together as a family, there are certain priorities, certain objectives, certain milestones, targets. As a collective group, you may want to set for yourself. But the interests of the individual members may contradict that of others. So you have tension. It may also be in clash with what the family as a group is trying to achieve. The same idea applies when it comes to society. So just take Ghanaian society, for example. Society of over 30 million citizens, different ethnic communities, different geographical locations and all that. Our interests are not the same, different religious backgrounds, different ideologies, and so on. But you need to actually mediate these tensions, these contradictions, in order to achieve peace, in order to achieve social harmony. And according to Jhering, that is the purpose of the law, to actively shape society in order that law will be seen as a mediator that balances competing interests and advances social harmony. So with respect to balancing the social interests, the ultimate goal is to ensure or achieve peaceful coexistence. Of course, where we have competing interests, which may bring tensions and all that, if they are not managed, it may lead to chaos, or there may be implosion, and then there will be disorder. And you want to avoid that, because that will bring about destruction of society. So law is supposed to mediate between conflicting interests within society in order to achieve peaceful coexistence. And for that matter, von Jhering's idea that the effectiveness of law is measured by its ability to resolve conflicts and create a stable social order. Now, if law is being made use of to resolve conflicts and ensure a stable social order, then we can say that the law is effective. But where we have conflicts, where we have social disorder, then there will be question mark about the effectiveness of the law. Then from that perspective of Jhering, that law is a social tool, which serve as a mediator for balancing competing interests and achieve social harmony, that will have failed. So the effectiveness of law at every point in time is to find out, has the law got the ability to resolve conflict and create stable social order? So for example, when it comes to the labor front, workers or employees on one hand, and then the employers on the other, certainly we have conflicting interests. Workers or employees would like to have more salary, would like to have more paid leaves and enjoy more vacation, would like to get so many good things as part of their welfare package. But that will also mean that the cost of running the organization from the point of view of the employer is going to go up. And where the cost goes up, it will definitely impact on profitability. After all, what is a profit? You arrive at your profit arithmetically by having your income, and then you deduct your expenditure from it. So all the things that the workers are agitating for will form part of your expenditure. And if huge expenditure is taken from the income, you may be left with something small, meaning that you have very reduced profit. Or if you're not even lucky, you may get a negative, in which case it will be a loss. So an employer does not like that. The employer would like to make more profit and all that. So you have that kind of tension over there. And then that can lead to conflict. And that is why law will, for example, have to come in. So we have something called collective bargaining certificate, right? If you look at the Labor Act, unionized groups are entitled to get collective bargaining agreement so that they can sit down with employer association or employers and hammer out terms of the engagement, negotiate packages for employees and all that. Again, when it comes to environmental law, we also see the need for balancing social interests, particularly when it comes to spatial development. You want to, somebody needs to develop something in the community. We need to go through what we call the environmental impact assessment process, IEA process. And part of the environmental impact assessment process is to try and find out those whose interests are going to be affected by the proposed development and all that. So the person going to do the development is very excited about it and whatever benefits it will bring to him. However, there are people too within the community whose interests are going to be affected by the development, and also even the very environment which they live within may also be impacted negatively. So you need to actually reconcile all these differences, and that is part of the work of the law. And again, when it comes to public health, again, there's a need to balance social interests. As individuals, we would like to enjoy more or less unlimited freedom. And of course, you know that in any civilized society, unlimited freedom is an illusion. It's not really possible. There will have to be some limitation here and there on our freedom in order that there will be peaceful coexistence and all that. So typically, you may want to smoke tobacco, right? Cigarettes, or some of you marijuana, or some of you, other, sort of prohibited drugs and all that, because you think that it makes you high and it makes you have fun. But that would also create health problems for society, especially when it comes to smoking, or even the other drugs, when you take them, because it may affect the soundness of your mental functioning, and you may become a danger to yourself and danger to other people around you. So there's a need to balance social interests, and public health will intervene to get that done. But when it comes to this, infectious diseases, remember the COVID-19, how compulsory, vaccination was introduced, and people having all manner of positions. But if you're also not vaccinated, apart from you being a danger to yourself, you're also going to be a danger to so many other people. So there's a need to mediate the tension between your individual interests and that of the larger society. And according to Jhering, the law is supposed to do all that. So Jhering will say that the purpose of law is to serve society. I mean, to put it simply, the purpose of law is to serve society. Well, von Jhering has actually left some legacy, and his legacy continues to also have influence even up to today. His ideas in terms of putting society at the center of law has paved way for modern interpretation of law, which focuses on practical impact rather than abstract purity. So abstract purity here refers to where you are looking at fidelity to formal statement of the law. Now, that is not what is important according to Jhering. And of course, if you look at the modern interpretation, especially the purposive interpretation, right? The purposive approach to interpretation, what they call the modern objective purposive approach, the MOPA, where, among other things, the courts or the adjudicator trying to interpret will go beyond just what the test and to try and find out what is the purpose which this law is supposed to achieve. And within that inquiry would also include what was the mischief, what was the problem which led to this law. And if you look at how the law is, what ultimate objective is it seeking to achieve? And all those things will be factored into how it is interpreted. So, for example, when we come to areas like privacy law, okay? Privacy law, for example, we have a tension between individual privacy on one hand, and also security and commercial interests. You go to, let's say, a company, right? You go to a company in order to ensure that you don't leak information which will hurt the interests of the company that you're working for. The company may have something like official email and insist that anything you are doing on the internet during working hours should be done through that email. That way, the company has access to the server and they can find out what sort of information you are exchanging in order to protect its own interests as a company and all that. Again, when it comes to fighting terrorism, when it comes to national security, it is important to sacrifice privacy of individuals. So therefore, the communication you are having on phone, the state may be interested in finding out what you are saying and who are you talking to, in order to be sure that you are not planning any evil like terrorist attack against the country. So here, too, because if the law is there to save society, then some of these sanctions need to be also managed or balanced. So let's look at a little bit more details of Eugene Ehrlich's contribution to sociological jurisprudence. And just as our friend Jhering, we summarize his contribution as a law as social instrument. For Eugene Ehrlich, we also say that he looked at the living law, the living law. And when Eugene Ehrlich introduced the concept of the living law, what did he mean? As we have explained during the introduction, that by living law, Ehrlich meant law that is practiced and observed in everyday life beyond formal statutes. So you want to observe what actually goes on in society. So you are trying to understand, to try and find the law from behavior in society, rather than trying to find the law from the textbook or from the Acts of Parliament. So Ehrlich is saying that don't just look at the statute book to know the law, but observe society. And as you observe society, that will help you to know the law. And that is why he called it the living law. So living law includes social norms, conventions, and practices that regulate behavior effectively, but are not necessarily codified. They are not reduced necessarily into the written law, but they very much regulate behavior in society. Well, we can think of so many social norms, conventions, and practices. Now, if you look at the news in Ghana, I think last week or the past 2 weeks, something has been going on in the social media. And that is very interesting. I don't know if there is anybody who is very familiar with it and can tell us more about it. What I saw is just a snippet, and my information on that happening is not enough. But if you have more information, you can raise up your hand and tell us more. That has to do with, I saw a picture in the social media where the president of Ghana was, I think he got to an event, and I think either he is greeting traditional leaders, and it is said in the story, I don't know the detail, but just what I saw in the social media, that a demand was made that the traditional ruler should get up and greet the first gentleman of the state. And then it generated some controversy. And then in another development, that the president also visited another traditional ruler. That's the king of the Ashantis, Asante, and he greeted him while he still remained on his throne. Is anybody aware of that? Can anybody tell us a bit specific so that we can use it to illustrate our current discussion? If you know, can just put up your hand and then I will raise your mic for you. Oh, you two don't follow the news. Anybody? Just put up your hand. Oh, okay. So you don't know that story. All right. Yeah, but that's what I saw. So I mean, I don't know the veracity or otherwise, but just taking it at this face value, what we saw. So Eugene Ehrlich is telling us that social norms, convention, and practices may not necessarily be codified, but may still regulate behavior effectively. So maybe like some of these practices, it's not in any written law, but maybe there are conventions or practices which suggest that you have to behave in a certain way as a sign of respect to the president or as a sign of respect to the traditional ruler or whatever as the case may be. It's not a perfect example, but just to let you know how certain things may not be in a written law per se, and yet, by and large, society may accept it to be regulating its behavior. So the bottom line or the core idea of Eugene Ehrlich's contribution to sociological jurisprudence is actually independence from formal rules. Formal rules, as I have said, rules contained in the written law, the official law, as it were. So Eugene Ehrlich would argue that the most effective and enduring legal norms are those that arise naturally from the social interactions of people. So if you look at it from that perspective, Ehrlich is trying to promote what we call bottom-up approach in lawmaking as opposed to top-down approach. So bottom-up simply means that, as he rightly said, that for him, the most enduring, that is, the most effective legal norms are those which arise naturally from social interactions of people. So the way that people interact in society, the various practices over there which regulate their interactions and relationships, those are the things which will crystallize, which will mature and become concretized as rules, as law. And for him, if you have a law which actually evolved naturally from the grassroots, from the daily interactions of the people, before it became like a formal law. Then that is the most enduring law. And so that one, you see, like the bottom-up approach, as opposed to the top-down approach. So the top-down approach is where Parliament sitting in Accra, the executive sitting in Accra, you get a minister, you get maybe an expert to put some ideas together on a particular policy. It's taken to cabinet grants approval, is sent to Parliament to go through the legislative process as spelled out in Article 106 of the 1992 Constitution, first reading, second reading, third reading, consideration stage, and so on and so forth. Then it is passed and is assented to by the president. That is the act of Parliament. Now, it may well be, and it does actually happen, that the law will have been made all right, having gone through the usual processes for making law. And yet, the people whose lives are supposed to be governed by that law may not only be aware, but may also not understand or appreciate what that law is trying to do. So that way, you have the formal law stated all right in the statute books, and yet the people who are supposed to be governed by it, they have no clue regarding what the law is trying to achieve. So that is the top-down approach, and Ehrlich, by implication, will reject that and rather embrace bottom-up approach. And that is why he said that the most effective and enduring legal norms are those that arise naturally from the social interactions of people. So Ehrlich believed that these norms often have greater influence on social behavior, than formal legal rules. And I think you can reflect on our legal system and try and get examples for yourself to validate or contradict this particular idea by Eugene Ehrlich. Yeah, so Ehrlich has made a contribution in his own way to legal philosophy. So his ideas, the concept of living law and all that, prompted a shift from a rigid focus on statutory laws to considering the real-life practices of communities. So, if we look at the history of legal thought, you will notice that there were times that there was so much emphasis on formal law and also logic. And of course, that is the basis for the legal methodology called doctrinal legal approach. Those who are doing dissertation on longest, I'm sure you have come across doctrinal legal approach, also known as black letter law. So black letter law or doctrinal legal approach is that approach which emphasizes restricting yourself to legislation and various forms of legislation, case law, and commentary on legislation and case law when you are trying to research into any area of the law that don't go outside these strict legal materials. The legislation themselves, and there may be subsidiary legislation related to it, academic analysis of the text of the legislation, judicial decisions applying that legislation and any critique of those decisions, and that don't go outside that. And that is what we call the black letter law approach to legal research, or what you call the doctrinal legal research approach. Now, Eugene Ehrlich's contribution of the living law certainly will frown upon black letter law approach or doctrinal legal approach, because for him, it is better to look at the real life practices of what? Of communities to understand the law. And of course, if you take customary law in Ghana, for example, that should give us a very good example of what Ehrlich is talking about. And that is why if we look at Article 11 of the Constitution, 1992 Constitution of Ghana, especially Article 11, Clause 3, which says that, quote, for purposes of this article, customary law means the rules of law, which by custom are applicable to particular communities in Ghana. So rules of law which are by custom applicable to particular communities what? In Ghana. So the real life practices of communities. And for customary law, we even have, if you like, two categories. We have customary law which have been pronounced upon by the court, so that you just cite reported case law and then you know the content of that particular customary law. And then the customary law, which has not yet gone through judicial ascertainment of customary law, and still they meet the criteria we saw in Article 11, Clause 3. That is rules of law, which by custom are applicable to particular communities what? In Ghana. Now, Ehrlich made important statements, quote, the center of gravity of legal development lies not in legislation nor in juristic decisions, but in society itself. So we've quoted this before. And by this, the understanding or interpretation of it is that true legal development is grounded in everyday lives and interactions of people. So as we study everyday lives, everyday interactions of people, that will help you to know how the law is developing, how the law is evolving. So Ehrlich's concept of living law is relevant for today. It's not something which is just part of things we see in the textbooks and we read. In trying to understand modern issues like even digital privacy, which we have explained, we can see living law evolving through common practices and social media norms. I give you an example. There is something we call take it down. Even those of you who are on social media platforms like Meta, Facebook, right? They have strict rules which they use to police content in order to ensure that people's privacy and other rights are not infringed upon by the way and manner you post or you manage other people's posts. In the same vein, if you go to YouTube, there are rules, especially if you are publishing something on the YouTube or you are commenting on something. And all these have been put together in order to ensure that various issues which are evolving every now and again are actually taken care of. You take the law of defamation, for example. you will notice how the emergence of technology and the various ways in which we interact through the cyberspace has even impacted on defamation. Now, let's take another scholar, Émile Durkheim. Émile Durkheim, that's another sociological jurist. So what did Émile Durkheim teach us as far as law and society is concerned? So he propounded the idea of social solidarity concept, social solidarity. And by social solidarity, Durkheim posited that law is a reflection of the type of social solidarity present in a society. So social solidarity here simply refers to the ways social cohesion is achieved. How do we achieve social cohesion? That we live in harmony. And then the intensity and content of social bonds. That is what it means by social solidarity. So that social solidarity, which is supposed to be present in society, will be mirrored or be reflected in the law. So that is why Durkheim said that law is a reflection of the type of social solidarity present in society. So that society, what is the level of social cohesion? How intensive is the bonding between members of that society and all that? So you come to our traditional society, for example, there is this emphasis on communalism, or that is a community, right? And we go to the Eastern Africa and Southern Africa, there's what we call the Ubuntu. Ubuntu, that is their own version of what they call the social solidarity. And as one anthropologist, Professor Mbete, will say, I am because we are. We are because I am. Then he also identified, apart from social solidarity, he also identified what he called mechanical solidarity as a type of social solidarity. So the social solidarity is a bigger concept he is talking about, the way social cohesion is achieved. But then there are various aspects of that. So one aspect is what he calls the mechanical solidarity. So on that, Émile Durkheim makes the point that in societies with mechanical solidarity, the law tends to be repressive or penal. And that enforces similarity and common beliefs. So that is mechanical solidarity. You have very repressive laws with strong sanctions or punishment to ensure that everybody falls in line. So maybe a typical example, if you take the tribal or some more customary community settings, over there, the norms are uniform and legal penalties are aimed at direct punishment or deviations. For example, in those days, you go to my hometown, Kuntanase, in the Ashanti region, Tuesdays, you are not supposed to go to farm. If you go to farm, that is an infraction of the a traditional rule or taboo, you'll be summoned to the chief palace, and you certainly not have any defense to such a charge. So you'll be sanctioned, as it were. And for that matter, on Tuesdays, you could be sure that there will be about 99.9% compliance of that rule. That Tuesday, we don't go to farm. Everybody should stay at home. And that is not in any written law. But just the chief, not the current chief, it's something which has been going on for many years. We also have another type of social solidarity known as organic solidarity. And by this, Émile Durkheim meant that in more complex societies characterized by organic solidarity, law becomes restitutive. Restitutive, that is a restitution. Restitution simply means that where you have done something wrong, the idea is that you've caused a certain imbalance or distortion. So you need to do the necessary remedial measures which will correct the imbalance or the distortion that you have created. So the law becomes restitutive and is aimed at restoring social order rather than punishing offenders. So when you are sanctioned, it's not understood as you being punished for the mere sake of maybe deterrence or anything like that, but as a way of restitution, correcting imbalance or distortion, which you have created by your disobedience of the law. Now, if you look at the modern societies, we notice diverse rules and interdependencies which lead to laws that manage relations and functions rather than dictate a common conscience. Now, Émile Durkheim also talk about types of law and social functions. Now, his theory, of course, the social solidarity, be it the mechanical solidarity or the organic solidarity, help us to understand transition or shifts from punitive measures, which were typical of simpler societies, to contractual and restorative legal system in complex societies. I'll give you an example. When it comes to law of contract, with respect to the law of remedies, award of damages, if you read the literature, cases like Hadley and Basendel, Vittoria Landry, Faro Atlantic, and so on, if you read all those cases, the wisdom behind the law with respect to award of damages is not to punish the contract breaker. And that is why Lord Dunedin was quite emphatic in the case of a Dunlop pneumatic tie against Selfridge, where there was an attempt to enforce penalty clauses in the contract. The court struck it down and said that when it comes to law of contract, penalty clauses are not valid because it defeats the purpose of awarding damages. The purpose of awarding damages, as we saw in cases like Robinson and Harman, is to place the innocent party, the party who has not defaulted the contract, or who has not broken the contract to a position, as far as money can do, where he or she will have been had the contract been performed as made. So if the contract has not been broken, has been performed, the innocent party, the other party, you have been at a certain stage, certain position. Now, because of the breach of the contract, his expectation interest has definitely been affected. So, in awarding damages, it will have to be done in such a way that he is put in the position that he will have been had the contract not been breached and performed as made. And if you look at all those kind of things, we notice that it's somewhat a reflection of some of the ideas which Émile Durkheim has actually put across, as it were. Now, if you look at the world now, there's so much interdependencies. And we even often say that we're living in a global village. And typically when it comes to internet, it is a very good example how our interdependencies have to be managed and avoid conflicts. Now, if there is any serious abuse of the internet, its effect may not only be limited to a particular country, depending upon the scale of, how the particular, malware or hacking or whatever is done. It can affect so many things, including airplanes whose systems are even linked to certain applications, which are all based upon computer, based upon internet, and so on and so forth. So, in a more modern society, we have so many examples and levels of interdependencies, which produce its own conflict. And the law is supposed to help to manage these dependencies as well. Now, let's come to Max Weber. Max Weber is another towering figure as far as sociology is concerned, and for that matter, sociological jurisprudence. So Max Weber talks about systematization of the law. And he defined law as rational, systematic, and predictable means of organizing society and exercising control. So the rational, systematic, and predictable means of organizing society and exercising control. And very soon you come across the notions of the law is a tool for social engineering. So all those ideas are based upon how Max Weber conceptualized law, that it is a rational, systematic, and predictable means of organizing society and exercising control. And his view of legal rationalisms involves creating laws that are systematic and predictable to maintain order and facilitate complex social interactions. So Weber, I say Weber, I don't say Weber, because we pronounce the W as V. It's a German. Yeah, so he also reflected on authority. And based on established belief in the sanctity of immemorial traditions and legitimacy of those exercising authority under them, he observed the following categories. So one, he identified charismatic authority. Charismatic authority from charisma. And charismatic authority derives from personal appeal and extraordinary characteristics of an individual leader. For Ghanaians, I'm sure one example which readily comes to your mind will be the late J.J. Rawlings, the late president. And people will say that, well, even if you didn't like him, he had a certain charisma which would endear you to him. He also identified legal rational authority. And legal rational authority, according to Weber, is rooted in a system of well-established laws and procedures, and the authority of office held, not the personal qualities of the office holder. So the charismatic authority is based upon the personal characteristics of the leader. But the legal rational authority is not necessarily based upon the personal qualities of the office holder, but more to do with a system of well-established laws and procedures, and also the authority of the office that the person holds. So that is the distinction between the charismatic authority and then the legal rational authority. Max Weber, legal rationalism produced influence on legal system. So among other things, his theory helps explain the development and function of legal systems, which are crucial in maintaining legal authority and also ensure compliance through predictable impersonal rules. So if you take like the legal system of Ghana, how it functions, the various aspects of it, they produce and are supposed to achieve the results not because of the personal characteristics of the people who are placed in various positions. No. So you have like the police, you have the courts, you have the lawmakers in parliament and all that. When it comes to their various constitutional functions, making the laws, enforcing the law and all that, the effectiveness and efficiency of those systems are not necessarily because of the personal qualities. Of course, the personal qualities of the people in charge may help, but the effectiveness and then the legal efficacy of those arrangements or systems are not dependent upon the personal characteristics or qualities of the people in charge. So that is the point I'm trying to make. So you look at the modern democracies, which rely heavily on legal rational authority rather than charismatic authority, where laws govern the behavior of citizens rather than traditions of personal leadership. So if you go to those countries where they have made coup d'etat, right? Where they've made coup d'etat, Ghana, we've had our own share in the past, but thank God, the past 3 decades, Ghanaians, I think we've become wiser, and we've all seen that it is sheer stupidity to do coup d'etats and pull the clock, the clock of development back many centuries. So I think that Ghanaians have been wise, and that wisdom should continue. After all, every 4 years, you have opportunity to decide who should be your leader. So why do you want to use senseless and then very British way to achieve power and also govern people against their will. So, but if you look at the democratic dispensation, as you notice, we have the various laws in place, we have the systems in place, and they are working. And the authority which the system command is not because of the personal characteristics. It's not charismatic authority. It is a legal rational authority. It's a legal rational authority. Now, Max Weber's insights into legal rationalism provide a framework for understanding how law adapts to societal complexities and changes. And we can think of so many examples. Very soon, we will use, after looking at the Roscoe Pound, we will use Gardner's interstate succession. So what is happening is that for this sociological jurisprudence, the scholars keep building upon each other's ideas. So we've seen Max Weber emphasizing legal rationalism. Now we have Roscoe Pound. Roscoe Pound, who propounded the well-known concept, social engineering. And Roscoe Pound conceptualized law as a tool for social engineering aimed at balancing individual rights with the needs of the community. So again, we have seen that so many sociological jurists are concerned about how to balance interests in society. So again, Roscoe Pound is also sharing the same view, and that for him, when we talk about law, it is actually a tool, an instrument for social engineering, which has the aim of balancing individual rights with the needs of the community. Now, social engineering, which Roscoe Pound has alluded to here, refers to the deliberate design and implementation of laws intended to shape social behaviors and outcomes in a way that aligns with societal values and goals. So it is a conscious deployment of law. Like you consciously, that's why I say engineering. When it comes, so engineering is a wonderful analogy or metaphor, which is being used by Roscoe Pound, because if you take engineers, right? If you're doing engineering work requires conscious thinking, conscious effort, conscious design. So you go to your desk as an engineer, and then you set up your design there and all that, having done the necessary analysis, the necessary adjustment, calibrations, and all that. Then you arrive at your design, which you think will be able to address or solve a problem which you have identified. So that is engineering. So that analogy is being deployed here by Roscoe Pound, and says that the social engineering for this purpose is the deliberate design, conscious or intentional or purposeful design, and implementation of laws which are intended to shape social behaviors. So you want to shape the way society behaves in order to achieve certain outcomes which will bring about alignment with values or goals of society. So that is what social engineering is about. Now, Pound emphasized the role of law in society as dynamic and instrumental. The law is not static. Law does not stand still. law moves beyond a mere system of rules to an active force that shapes societal structure. And for that matter, Roscoe Pound argued for the pragmatic application of law to solve societal problems, not just to adjudicate disputes or punish wrongdoing. So law is not just for adjudicating dispute or punishing wrongdoing. Of course, that is part of law, but then Roscoe Pound wants to tell us that law is much bigger than that. And I'm sure that some of you who are disciples of Rudolf von Jhering, you have started shaking in your chair that your universe is collapsing now, because your master Jhering seemed to emphasize the adjudication function of law so much. But then Roscoe Pound is also telling us that that is not all that there is to law. There's something bigger than that. And that is the law is supposed to be used as a tool to provide pragmatic or practical solution to problems of society. Now, he talked about balancing interests. Balancing interests. And the various ideas which Pound has shown out there focus on the necessity of balancing competing interests within society to achieve justice and functional harmony. Of course, just like his other sociological jurists, they all acknowledge that society is made up of competing interests, and there's a need to manage these competing interests so as to have harmony. And he sees in law the potential of social engineering, and that will enable you to manage some of these competing interests. So, for example, when it comes to environmental law, right? Environmental regulation, it tries to achieve a balance between economic growth and environmental protection. How? Now, we are all concerned about global warming, climate change, and we don't know whether the climate as we have it now is going to remain the same the next 2 decades. We don't know. Only the Almighty God knows. But there's one thing we know, that we are not using the environment well. And because we don't use the environment well, there are certain problems that we are creating, which will definitely impact negatively on the environment, and for that matter, the climate. So how does this environmental regulation illustrate the point of balancing interests? You need to, let's use galamsey, right? Let's use galamsey. People would like to go after the gold in the ground, so that, of course, when you have gold, you get money and all that. But going for the gold in the ground may result in destruction of the environment, the water bodies, the vegetation cover, the animals would use that particular area as their natural habitat. Because they're going to do all that, they will be chased out and all that. So you've caused serious distortion in the environment, because you want to create wealth for economic development. So you need to get the law which will come to try and balance these competing interests. And then we've also cited like labor laws is also try to mediate between employer demands and worker rights, as we explained earlier on. Now, if you look at modern legal practices, the ideas of Roscoe Pound are felt in various ways, especially when it comes to development of case law, where judges weigh multiple factors to reach equitable decisions. There are a lot of cases, at least when it comes to, especially in the area of thought, right? The area of thought and in the area of contract. A lot of factual scenarios come up in the court, and then the court will need to reflect on the multiple factors so as to achieve a decision which is fair. Even when it comes to land law, right? Land law, especially this concept of adverse possession, and so in relation to section 10 of the Limitations Act, which says that where somebody has had has been on your land continuously and has excluded you for a period of 12 years, then that leads to extinguishment of your title and so on. And again, the doctrines of laches and acquiescence, where you have an interest in land, you see someone developing it, you stand by, you don't do anything, and so on. After a long time, when the person has finished and enjoying the property, you now go to court and then you seek to demand it. Then so question is whether it is equitable for you to be given possession, especially when you have stood by, when you had every opportunity to have asserted your title, to have asserted possession. Again, when it comes to consumer protection, we also see relevance of Roscoe Pound's ideas, because you also need to balance interests of businesses and consumers. That is important. And we also see how Food and Drugs Authority, used to be Food and Drug Board, how they also come in to try and play some of this mediating role. Manufacturers, businesses would like to make more profit, oftentimes at the risk or cost of health of their consumers or those who use their products, but they don't care so much. So you need to get a regulator to come in to set the ground rules and ensure that these competing interests are properly balanced. Yeah, so sociological jurisprudence generally continue to play a crucial role in interpreting and shaping laws to reflect and address contemporary social realities. Now, if you look at legal research, until the last 4 decades or so, legal research was heavily black letter law. That is doctrinal, as I explained earlier on. But with the emergence of and popularity of sociological jurisprudence, there has been overwhelming interest in what we call law and society research, trying to look at the law in action, the law in the context of society. Again, sociological jurisprudence helps in crafting laws that are not only legally sound, but also socially sensitive and relevant. So look at the LGBT bill, for example, right? LGBT bill before Parliament. I am sure that if a referendum were to be held over the LGBT bill as whether it should become law or should not become law, we will have overwhelming response by Ghanaians, one way or the other, as it were. Now, sociological jurisprudence also helps to address present societal issues such as social justice, equity, and public welfare, because the emphasis is on trying to observe interactions, behaviors, and practices in society. And as you do that, you're able to see that which is not fair, that which is not right. And then you begin to see how you can consciously mobilize law and deploy law as a tool for social engineering in order to achieve desired or desirable outcomes. We can cite various examples in our country, Ghana. We take family law, for example. When it comes to adoption, adoption has undergone various reforms in terms of procedure. And because of various practices which have been observed, not only in Ghana, but across various countries, human trafficking and all that. And all these have resulted in the Hague Convention and other conventions which have been domesticated. And now we have a more comprehensive, robust, and then rigid adoption system. Then when it comes to also spousal property rights in Ghana, you notice that pre-Mensa and Mensa jurisprudence, how there was so much emphasis that when there was a marital dissolution, there needed to be concrete proof of contribution before a spouse could make a claim to appropriate fraction of the matrimonial property and so on and so forth. Then Mensa and Mensa, as you know very well, came to say that, well, if you look at the Constitution, it anticipates that the Parliament will make laws to regulate these rights. But where Parliament has not come out, then we're going to use equality is equity and create a presumption of 50-50% between the spouses. And how that jurisprudence has also developed further to say that, okay, now we are still interested in you proving, if you think that you contributed more than the other, then you need to prove it so that you're able to come out with a sharing ratio, which will be fair for the parties, having regards to the various contributions that they made. Again, when it comes to criminal justice, you also see how various developments in society have resulted in changes in the law. I can talk about the plea bargaining and so on. I want us to do a case study. Let's use the interstate succession law in Ghana as a case study. A case study in terms of how law is an instrument for social engineering. That's what I mean. Now, I will leave the slide with you, but the point to remember is that the interstate succession law, PNDC law 111, I think we had it in 1985. Now, prior to the interstate succession law 1985, PNDC law 111, as far as intestacy, that is where a person died without making a will, regarding how his or her properties or affairs should be attended to, the position of the law was that the various, customary system one belonged to, or one personal law, is what was going to determine. So therefore, if your customary community was the matrilineal system, then the matrilineal system, we know the rules. If it's a patrilineal system, we know the rules, and so on. And you remember the sad case of Imre Kofi Antobam, where the point was made that if your parent died, your father died, and he had you're living in the house and so on. Because I'm talking about the pre-1985 Pennies Law 111. It was not automatic that you could continue to live there unless you have good behavior, and then the family of the deceased parent actually agreed or permitted you to remain there. But as you notice, all these were fraught with injustice and unfairness. How could you say that somebody's father or mother, as it were, had made the property, and that the child could not be guaranteed the right of saying that that was unfair? So in 1985, PND's Law 111 came and introduced a complete new regime, which said that, yes, to address problems which children and spouses face upon intestacy, we are going to have this new formula. So that gives you a clear example of how law is used as a tool for social engineering, as it were. Now, I have this question. How can law better adapt to societal changes? In other words, how can law be made more responsive to changes in society? Well, there will be a need for more emphasis of flexibility in legal framework. And here, it is suggested that there should be dynamic legislation. That is to say that law should be made or crafted with mechanisms for periodic review and amendment to adapt to new circumstances without needing complete overhauls. So when you make a law, you could, for example, give power to a minister of particular state department so that they could come up with legislative instruments to provide for regulations which may probably change certain aspects of the law, which does not require that there should be entire re-enactment of that law or repeal and so on and so forth. So that is there should be that kind of a sunset clauses for automatic review or expiration. So certain provisions, you can, for example, put a timeline on them so that when those timelines have expired, those provisions will have expired, and so on. Or you can also have adaptive regulation. We can adjust to technological or social innovations. There are certain areas of society which witness rapid changes so much that law cannot keep pace with those changes. So if you want the law to better adapt to societal changes, it is necessary to, for example, have adaptive regulation which can allow adjustment to these technological or social innovations. Another strategy which can be harnessed to make law adapt to societal changes is pilot programs. And here we are saying that you should implement temporary or experimental trial laws to test how well the law works in practice before full adoption. So instead of, for example, if you want to make a law to regulate the whole Ghana, instead of making the general legislation, you could decide to have a pilot test so that in a particular community or a particular aspect that is tested, and if after a while the results are reviewed and are good, you can now decide to extend it to other parts of the country. The third strategy for making law adapt to societal changes is to enhance public participation. That is very important. Enhance public participation. So you have more of a bottom-up approach rather than top-down approach. So there should be community involvement. You engage with community groups, stakeholder groups, and general public during legislative process in order to gather diverse views or perspectives and ensure that laws reflect the current needs and values of society. So that way, you'll be sure that the law will be responsive to societal changes. And related to the enhancement of public participation is a public consultation and hearings. There should be scheduled fora and consultation that provide crucial insights into the public's view on existing law and proposal for new ones. So it's not enough for Parliament to just go and sit there and be debating. It is important to also hold consultations and hearings for people to articulate their sentiments and view on certain things, as it were. The fourth strategy is the use of technology. You can use technology so as to help law to be more responsive to societal changes. How? First, you could have digital feedback mechanism. Now, Ghana, we have gone, everything we are trying to digitize, which is a good thing. So you can collect people's reaction or feedback using online platform so as to accommodate people's concerns in laws and policies which you are making. And that way, you also ensure that the citizens are participating in governance, which is good. Again, using technology, you can also have a data analytics. So you can have various data-driven approaches which will enable you to assess impact of laws and predict future trends. And this will be very useful when we are making legislation. A legislation which will be proactive rather than reactive. Proactive means that we're able to anticipate problems or challenges which will happen in future so that we provide the necessary panacea or solution to those challenges. Reactive, on the other hand, means that we don't think far enough, as somebody will say, I cannot think far. And we rather wait for problems to occur. And then once we are in the thick of the problems, we think of how to deal with those problems. So that is a reactive approach rather than proactive. It is better to be proactive than to be reactive. The fifth strategy to make the law adapt to societal changes is interdisciplinary approaches. That is to say that you should go outside the law in order to get input to improve the law. And in this regard, sociological research is very important. You do sociological studies into legislative process, the findings that you have, you integrate them into the legislative process, and this will help you to understand better the root causes of issues and the potential impact of laws. Because how people behave, how people interact, those are the things sociologists are interested in. So if we can understand those things, then that will help us when it comes to law making. There's also the need for collaboration with experts, other experts, sociologists, economists, technologists, and so on. They can all provide a well-rounded understanding of the potential effect of legal changes. So if you leverage on all this, then you can make the law better adapt to societal changes. The C strategy is education and awareness. There should be legal education reform to focus on technology, whether you like it or not. The world that we are living now, you cannot avoid technology. We are all caught up in it. So legal education should build people's competencies regarding technology, sociology, international human rights. And international human rights, for example, provide another challenging vista, especially so now that we have a globalized and digitized societies. So there are certain matters which are unique to certain countries. And yet, as that country is not going to be an insula or an island, and you have to interact with people from other parts of the world, you may need to have an open mind and accommodate diversity. So there's also the need for public awareness campaigns. I mean, that is very important to ensure that the laws are understood and effectively implemented. Another way to make law adapt to societal changes is to have responsive judicial system. So case law development, judges should be more creative and flexible in order to ensure that they render decisions which adapt to changing social norms. There should also be speedy resolution of disputes, as it were. As somebody would say that justice delayed is justice denied. So let's keep these things in mind. So just before we go, just few criticism and limitations of sociological jurisprudence. As we have noted, no theory of law is immune from criticism. No theory of law is sacrosanct. We definitely have one challenge or another. So what are some of the criticism and limitations of sociological jurisprudence? So one, potential bias. Now, incorporating sociological perspectives can introduce subjective biases into legal interpretation, and that will have the potential to skew justice. There's that risk of bias. There's that risk of bias. And of course, there's also challenges in objectivity, as it were. Because law is supposed to be impartial and universal. But as you emphasize observing what goes on in society, that way you enter into the realm of subjectivity, because our observations and all that are not uniform. And that can also affect the impartial and universal quality of the law. And again, you may also have practical limitations, because implementing laws based purely on sociological principle can be impractical for the reason that society is dynamic and diverse. Society is dynamic and diverse. And for that matter, if you want to always go by sociological principles, even the very things you observe from society, those things are not going to stay constant because society itself is ever changing. So you made certain observation from your studies into society 5 years ago. That is fine. But before your findings are even published, so many changes have taken on in society. So that is the other challenge, as it were. So these are some of the things that we have to keep in mind. So I will take questions before we break and come back for company law. I think about in 10 minutes time. Yeah, so if you have any questions or contribution, you can just put up your hand.